morning presentation is the Brooklyn Public Library Business Library, and I'd like to introduce Maud Andrew Quintana, who's fixing me right about now. But I'm a former prosecutor, so I don't know if everyone, you heard me, didn't you? Do I need to go through that all over again? And so, Maud, come on up and talk to us for a minute.
All right, welcome to the Business Library. We're delighted to have you with us this morning. We're very proud to be partnering with the New York City Commission on Human Rights and to have Robin Stutman from the Department of Justice and Tom Shea from the New York Immigration Council here today. The Commission does extremely important work every day to protect New Yorkers against discrimination and strives to ensure that our city benefits from a diverse yet harmonious population. The Commission's success is not just a matter of enforcing the law, but of educating the community by increasing awareness and understanding. They promote the tolerance and fairness that we all enjoy. Today's program on avoiding immigration-related employment discrimination will address these issues and that employers are facing with increasing frequency as more and more individuals come from all over the world to live and work here in New York. The Business Library, as part of the larger Brooklyn Public Library, also serves individuals from dozens of countries who speak numerous languages. We are frequently the first place individuals go to seek information and resources, whether they're business owners, employers, those looking for employment, or just hoping to start a company. The Business Library buys and researches, builds, and investigates the resources needed to build and grow a business and run a business. As I know many of you are in very large companies and in the human resource department. We provide free and convenient access to much of the same information that private corporations spend a great deal of money on. And you don't even need to visit us to use our resources. The Business Library can be your remote office assistant in two ways. You can call us from your place of work or home with your questions. Secondly, you can access information over the internet using our electronic resource databases from home or work 24 hours a day, 7 days a week. You can get access to magazine and newspaper articles, gather company and industry information, or build lists of potential customers or potential suppliers. To use these electronic resources, you'll need a library card. We can help you with that at the end of the program today. And we would be happy to show you how to use these resources connecting to our library's website, giz.brooklynpubliclibrary.org. Additionally, the website lists resources that can help your organization. You can also use our website to find out about programs at our library, such as the one today. Every week of the year we have programs, and they cover topics such as new industry trends, how to write a business plan, using the internet to market your business, and more. Once again, we're really happy to be partnering with Commission on Human Rights this morning. I think it's a wonderful program. I hope to see you all again in the Business Library. Come back on a Wednesday morning for a tour if you want to learn more. And once again, thank you very much.
Thank you. Well, the woman standing to my left, we're old friends now. I guess we've been in this business for a little while now, and that's Robin Stutman. And she is Special Litigation Counsel from the Office of Special Counsel for Immigration-Related Unfair Employment Practices. From the Civil Rights Division of the U.S. Department of Justice. And we also have Tom Shea over here to my right, who I just recently met, but he's the Director of Training Institute at the New York Immigration Coalition. So I want to thank them for joining us this morning, and they're going to be our guest speakers. The New York City Commission on Human Rights has long been actively involved in informing employers with immigrant workers about their rights and responsibilities under local law and the Federal Immigration and Naturalization Act and the Immigration Reform and Control Act. Employment-related discrimination complaints are the largest percentage of the complaints that we receive at the Commission. And after that would be housing, just because everyone always says, what's the next? Housing. Okay. Of the 920 recent employment-based discrimination complaints filed with the Commission, 1 in 5 was on the basis of national origin or citizenship status. And in our 5 borough-based field offices, or we call community services centers, 29% of the 2,273 employment-related inquiries we received in the last couple of years related to immigrant issues. And so you can see that this is really it's sort of a large looming issue that's going to stay with us in New York. I don't think it's something that's ever going to go away in New York because we, after all, are a borough. We pride ourselves in our immigration. Immigration status and the regulations and paperwork associated with it are very, very complex. And today we're actually kind of excited because we're going to get information from Robin hot off the presses about the new I-9 forms that just came out last night. And so if you notice in your packets, we were copying all last night, and you'll have it, and so you'll be the first to really sort of hear about it, and you'll hear about it from the person who has to make it effective. And so that's really good. This year, as in the 2 earlier years, the Commission and our partner, the New York Immigration Coalition, we were honored to receive a public education grant from the U.S. Department of Justice and Civil Rights Division. And so with this team support, our program this year will be directed at ESOL classes. And so we will be doing these types of presentations to not only employers like yourselves, but to also to new immigrant employers.
Thank you, Commissioner Gatling, and I'd like to thank all of you for being here today. I think it shows a sincere intent on your part to, in this effort to avoid immigration-related employment discrimination. I'd like to thank the Commission on Human Rights for all the work that they put into this project and to this program today, and also thank the Brooklyn Public Library for hosting it. And also I'd like to thank the Office of Special Counsel for Immigration-Related Unfair Employment Practices for funding this project. My name is Tom Shea. I'm the Director of Training and Technical Assistance with the New York Immigration Coalition. The New York Immigration Coalition is a nonprofit organization that serves as an umbrella agency for approximately 200 member agencies that serve immigrants, asylees, and refugees throughout New York State. And we've been invited to partner with the Commission on Human Rights on this program. And what I will be doing essentially is, since as Director of Training and Technical Assistance with my office, I train the staff of our member agencies and the staff of nonprofit immigration legal service programs on immigration law so that legal practitioners can learn and maintain their competence in immigration law, as well as I provide presentations in immigrant communities on issues that impact immigrants, primarily like basic immigration law issues. And with this program, with the ESL classes in the public libraries, I will be present to provide information on immigration law to the people who attend these classes. And again, the vast amount of work ever put into this, I have to give credit to the New York City Commission on Human Rights, because they've really developed this whole program, and I thank them for inviting us to participate in it. So actually, I think I just have to hand it off now to Robin, and thank you all very much.
What we're going to do today is talk to you about immigration-related employment discrimination and how you can avoid problems and not be accused of that. So what I'd like to do is start off with a PowerPoint presentation, and then I brought some vignettes with me on video so we could actually see how these cases look and sound and feel and smell in the real world, and talk about what's going on with them. We have a new I-9 form, which is the Employment Eligibility Verification form, which is literally hot off the presses, and the Commission's been good enough to copy those for you, and including the employer handbook and some information on that. So you really literally are the first to have it, and I'll be happy to answer any questions on that as well. So why don't we go ahead and get started. What I'd like to talk to you about today is the Immigration Reform and Control Act of 1986, which is what originally was the statute that passed our office and the employer sanctions of the immigration law. And what I mean by employer sanctions is where employers are prohibited from knowingly employing undocumented workers. So, for the first time in 1986, Congress legislated that employers cannot knowingly hire undocumented workers. In order to enforce these provisions, they also implemented what we call the Employment Eligibility Verification requirements, where now, for the first time, employers are required to verify the employment eligibility, that is the identity and work authorization of all their new employees. This is the infamous I-9 form. Are you all familiar with the form? I see a lot of heads shaking. Okay, good. So you know what I'm talking about. And of course, there's lots of questions about what documents are acceptable for the form and who's authorized to work and who's not authorized to work, and the documents often are changing, and so there's a lot of confusion and problems associated with that I'd like to address here today as well. Now, at the time this law was passed, there was also a big concern that it would engender widespread employment discrimination against those who looked and sounded foreign. And so Congress also passed the anti-discrimination provisions, which my office enforces, and I'd like to talk to you about that today as well. And as the Commissioner said, we're the Office of Immigration-Related Unfair Employment Discrimination in the Department of Justice. We're in the Civil Rights Division, and we like to say we have the longest name and the shortest budget in the department. Basically, we just call ourselves OSC, and we're headed by a presidential appointee, a special counsel, who actually we have a new one starting on Tuesday. So again, that's news here, and it's something brand new. And his name is Patrick Shen. He'll be starting on Tuesday, and we'll be moving forward with enforcement of this statute. We enforce the anti-discrimination provisions of this law, and there's several types of discrimination that are prohibited. One is citizenship status discrimination. We also prohibit national origin discrimination in employment, something called document abuse relating to the I-9 form, and retaliation. And I'll go into all those at greater length and explain to you what I mean by that. But first, our citizenship status discrimination provision protects U.S. citizens or nationals, asylees, refugees, recent permanent residents from citizenship status discrimination. So what do I mean? I mean discrimination because someone either is a U.S. citizen or is not a U.S. citizen, or based on the type of work authorization they possess. So for example, we had a case early on against a large Fortune 500 airline where that airline said, we're not going to hire anyone who has a future expiration date on their work authorization. And we found this to be illegal citizenship status discrimination because the individuals were authorized to work, and even though their work authorization would expire in the future, there was nothing to say that they wouldn't be renewed, and there's nothing to say that U.S. citizens wouldn't leave, in a short amount of time either. So we found that that was not a defense, and that would be an example of our citizenship status discrimination jurisdiction. Now, we also, this provision is a little more limited. It only protects, as I said, U.S. citizens, nationals, permanent residents, asylees, and refugees. So temporary visa holders are not covered, and people who are just applying for those statuses are not covered. But basically, U.S. citizens are covered. So we also have cases where individuals will claim that the employers prefer to hire undocumented workers because they can exploit them, they can artificially depress wages in the industry, perhaps they're tied to them in terms of employment, and so that also would constitute citizenship status discrimination. There was a case here in New York City involving the Iron Workers Union, where the Iron Workers Union claimed that the employer was rejecting qualified union workers, U.S. workers, because they were trying to get a labor certification for an undocumented worker already in their employ. And so they instituted very restrictive hiring qualifications, such as the ability to speak Polish for an iron worker, and conducted sham interviews and things of that nature, and then rejected the U.S. workers. And so in that case, the court found that that was indeed citizenship status discrimination, where an employer prefers undocumented workers over U.S. workers. One important point to keep in mind is under this statute, undocumented workers are not protected because, of course, Congress can't sue employers for employing undocumented workers and then turn around and sue them for discrimination against them. So this statute only protects authorized workers. Now, there's a couple of exceptions to this citizenship status discrimination provision that's important to keep in mind. One very important exception is, of course, where U.S. citizenship is required by law, regulation, government contract. We call this the government contractor exception. Then, of course, those types of citizenship status restrictions are completely legal. But you have to keep in mind that the restriction has to be tied to a particular position. So, for example, if you have a government contract that requires a security clearance for an engineer, you can't then say, okay, well, my whole workforce has to be U.S. citizens. It's only that particular position covered by the government contract that you can restrict the citizenship of the employee. Now, there's a little known exception as well where employers can prefer U.S. citizens over non-citizens if the two applicants are equally qualified. But again, you'd have to compare two specific applicants. We had a case against another airline where the airline said, well, I'm only going to hire U.S. citizen pilots. I'm only going to look at the U.S. citizen applicant pool until I run out of qualified citizen applicants, and then I'll look at the non-citizens. You know, that would not be legal. But if you have two specific applicants and the U.S. citizen is equally or better qualified, you can prefer them on the basis of citizenship. We've had other cases, including another one here in New York. New York's an active area for us, as you can imagine, and that's why we're so happy to be here in partnership with the New York City Commission on Human Rights. But we had another case where an employer said to a Puerto Rican worker that in order for me to hire you, you need to show me your green card. And of course, Puerto Ricans are U.S. citizens, and so she didn't have a green card and couldn't show a green card, and she was rejected for employment. And that, again, would constitute citizenship status discrimination because based on her perceived citizenship status, that is, he didn't believe she was a U.S. citizen, they rejected her documents and they rejected her for employment. Now, subsequent to this case, the document abuse provision was passed, and so today we would actually bring it on the basis of document abuse as well, and I'll talk more about that later. But those are some of the types of practices as employers you want to stay away from, because that's where you start to get into trouble. We also have cases involving temporary visa holders, and right now this is a very active area for us in the IT industry. And I don't know if you've all been following, but you know there's been a lot of proposed legislation back and forth on these H-1B visas, which are professional visas to bring in temporary workers, and particularly they're used very heavily in the IT industry. But basically, we've had a lot of charges from U.S. IT workers saying that employers are preferring the temporary visa holders over the U.S. workers to allegedly depress wages in the industry and also to have a workforce that's tied to the employer. We have a lot of these cases, a very hot area for us right now in the IT industry. As you know, there was a downturn in the industry. There were a lot of laid off U.S. workers. And so that's been a very active area for us. But again, if we can prove that the employer is preferring temporary visa holders over U.S. workers based on their citizenship status, that would be a violation of the statute as well. And it also occurs in the agricultural area where farmers will bring in workers on temporary H-2A visas, and it's alleged that the U.S. workers are being discriminated against in employment because of the preference for the temporary visa holders. So again, those are types of practices you want to stay away from as employers. You also want to avoid any type of discrimination in the hiring process, because that is also covered by this statute. So for example, when people are applying for employment, you want to make sure that you treat everyone equally in the application process. You don't want to pre-screen immigrants or require that they show their documents up front or more highly scrutinize their documents versus your native-born U.S. citizen applicants, because that also would be prohibited under this statute. You want to just make sure you have a uniform process for all applicants across the board. Now, we also cover now national origin discrimination. And what do I mean by national origin discrimination? Of course, I mean discrimination based on the fact that someone was born in another country, appears to be born in another country, speaks with an accent, English is not their first language, their ancestry is from another country, that type of thing. And we cover discrimination with respect to hiring, firing, and recruiting and referring for a fee, which would be the same for citizenship status. Now, what Congress did with this statute, because of course national origin discrimination in employment was already covered by Title VII of the Civil Rights Act of 1964, but what Congress did was it said, we want to cover smaller employers as well. And so they gave that jurisdiction to my office, and we cover basically employers with between 4 and 14 employees for national origin discrimination. The Equal Employment Opportunity Commission, the EEOC, continues to cover the larger employers, those with 15 or more generally, for national origin discrimination. We have a memorandum of understanding with the EEOC so that if the charge is filed with the wrong agency, we can refer it to the correct agency, and we can stop the statute of limitations from running and basically consider that charge to be timely filed, even though it was filed with the wrong agency initially. Now, in terms of protected individuals, this class is much larger. It covers all authorized workers for national origin discrimination. And we had another case in New York involving a small law firm where we had a charging party who was originally born in Uruguay, and she was now a naturalized U.S. citizen, and she spoke with an accent. And so she called the employer in response to an ad that ran in the New York Times for clerk typist positions, and was told immediately when she called, oh, sorry, those positions have been filled. She thought this was very odd because the ad had just run, and so she had her daughter, did a little informal testing, and had her daughter, who was a native-born U.S. citizen, call, and her daughter was told, oh, come on in, we have plenty of openings. They then reversed this process the following week when the ad ran again, and the daughter called and was told, yes, come in, we'd be happy to interview you. And when the mother called, she was told, no, sorry, no openings. And so we brought that case based on accent discrimination, which would be a form of national origin discrimination, and that case ended up settling. As a clerk typist, of course, accent should not be a legitimate business reason to reject anyone for employment. And so you want to be careful when you are hiring to avoid any type of language discrimination, accent discrimination, anything of that nature. Of course, if the ability to speak English is a bona fide occupational qualification, that is, if it's necessary for the job, that would be another thing, but generally, accent should affect the ability to do the job. So you have to look at, the type of job that you're hiring for, what the qualifications are, and make sure that you're not discriminating against anyone because of their either inability to speak English well or the fact that they speak English with an accent. Now, I mentioned when this law was passed, there was a big concern that it would cause discrimination against authorized workers. And so Congress charged at that time it was the General Accounting Office, now it's the Government Accountability Office, but they didn't have to change their acronym, the GAO, and the GAO studied this law, and as a matter of fact, in 1989, the GAO found that the law had caused widespread discrimination against those who looked or sounded foreign. And so in 1990, Congress passed what we call the document abuse provision. And what that does is it prohibits employers from requiring more or different documents than are required by the I-9 form. And I'll talk to you more about what that means and how that actually operates in the real world. But basically what the GAO found was that for the first time after this statute had been passed, employers were now requiring U.S. citizenship for jobs that they had never required U.S. citizenship for before and that had no legal basis. They were also requiring more documents or different documents from people than they had before. And many times it was because they just didn't understand what documents were acceptable for the form, or they were concerned that they didn't want to get in trouble with the INS at the time, and so they were kind of backlashing and just, in an abundance of caution, just requiring more documents than are required. And of course, that causes a lot of problems because you end up rejecting people who are fully authorized to work and have the proper and sufficient documents to work, but are being rejected because they're immigrants or they look or sound foreign, and the employer is concerned that they're not authorized to work. So you want to be very careful when you're completing the I-9 form that you only request what's required by the form, and I'll talk to you a lot more about that. Where employers require more or different documents than are required by the form, or reject valid documents that appear reasonably genuine on their face, that is what constitutes document abuse. So, for example, in the Washington, D.C. area, we had a case against a large janitorial services firm. It's a nationwide firm, and they had hired a naturalized U.S. citizen from Guatemala. And he was the janitorial supervisor for the crew, and he was doing the I-9 forms and verifying the employment eligibility of his crew. And the company told him, okay, well, remember to copy everybody's green cards. And so they had individuals from El Salvador who were here on temporary protected status who didn't have green cards. They had, at that time, unrestricted Social Security cards, which means the Social Security cards that don't have the legend, not valid for work or only valid with DHS employment authorization, but just your regular Social Security cards that are acceptable to prove work authorization for the form. And they also had state IDs, and they were turned away because they didn't have green cards or permanent resident cards. And then they turned to the janitorial crew supervisor and said, oh, and don't forget to copy your green card. And he said, well, I'm a U.S. citizen. I don't have a green card. I have a driver's license, I have a Social Security card, and I have a voter's registration card, which of course only U.S. citizens can have. And they said, we can't accept that. If you're really a U.S. citizen, we need to see your U.S. passport or your certificate of naturalization. And he refused to provide those because he believed that it was illegal to copy the U.S. passport, which for most instances it is, but not for this purpose. And he was fired. And so we brought that case based on document abuse because they were requiring more documents or different documents than the form requires. We also brought it based on citizenship status because based on his perceived citizenship status, they were requiring him to show more documents and discriminating against him in the hiring process. And we also brought it based on what we call a pattern or practice. Because it was the company's standard operating procedure, we basically brought it on behalf of all workers who were subjected to this practice.